The Fair Debt Collection Practices Act. Brought to you by Kenneth Chabert at yourlegallagout.com. Your advantage if you're being sued by debt collectors. The Fair Debt Collection Practices Act, FDCPA, is the centerpiece of legal protections for consumers against debt collectors. The law was passed in its essential form in 1977, and its goal was to protect debtors against the abuses of debt collectors. The debt collectors are still going strong, but it is a good law all the same. Before the act, the debt collection industry was routinely engaging in the most infamous sorts of behavior, with no consequences at all. From calling debtors at all hours of the day or night and subjecting them to streams of abuse, to discussing their debt with children, and they sometimes told the children that their parents would go to jail and that the children would end up in an orphanage, and discussing it with neighbors and employers. Debt collectors also frequently misrepresented themselves as attorneys and often threatened legal actions which they were powerless to take or never intended to do. And they often attempted to, and did, collect debts that either never existed or were long and unenforceable because of statutes of limitation or bankruptcy, and they got them simply because they were able to intimidate the people into paying. Whatever the staid spokespeople of the debt collection industry may say, this is the background of their industry, and it is still going on. All of it. It's all about the money, of course. You can find the Fair Debt Collection Practices Act in the federal laws at 15 United States Code, USC, Section 1692, et sec. That means and the following sections. It was enacted to put a stop to these extreme behaviors in 1977. But because the people intended to be protected by the act are underrepresented by lawyers, and because of the explosion of debt litigation over the past decade, many of the old abuses still continue. Still, the FDCPA is in many ways a model piece of legislation, and it does have power. Part of what makes the law so powerful is its flexibility. In addition to making certain specified actions illegal, the Act also more generally makes behaviors that are oppressive, false or misleading representations, or unfair practices illegal. This means that whereas in most laws the would-be wrongdoer is free to craft his actions around the specific language of the law and find loopholes, under the Fair Debt Collection Practices Act at least, the consumer can be just as creative. The Supreme Court has ruled that an unfair act can be shown by demonstrating that it is at least within the penumbra, that's legalese for shadow or just about, of some common law, statutory, or other established concept of unfairness. That's all pretty broad. The price for this flexibility, however, is that the remedies, what you get if you prove the case, are less powerful, and this may be why the practices, or at least one reason why the practices are still occurring today. There is some help for that in that you can often also sue the debt collector under other laws for the same or similar behavior. I'll explain why you might do that in another video. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but I do know the legal process and debt law very well, so use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallagout.com. Get my litigation manual and forms, and defend yourself from the debt collectors.